Hi, it's Mike DelSignore, and behind me there is my office in Westboro, Massachusetts. In today's video, I want to talk about what happens if you're charged with a second OUI out of the Westboro Worcester District Courts. I'm Michael DelSignore, and I'm a Massachusetts OUI lawyer. I've handled a lot of cases out of Worcester County. It's something I've been doing for my entire career. I have a passion for it. I speak to other attorneys about how to defend OUI cases. I go to every seminar I can go to on these cases, and we've developed a real niche in handling these cases and have helped a lot of people, and I'd like to help you. So in this video, I'm going to talk about second offense OUI, and there's a couple different variations of this. So first thing I ask anyone who calls me about a second OUI is, when was your first offense? Because it's going to make a difference in the license loss. So if your two offenses are more than 10 years apart, then it can be treated differently. You can get what they call the Cahill resolution. You might hear that term in court. That's the name of the case that created the resolution, where someone can get a hardship license on the refusal suspension if the judge treats the second offense as a first offense and gives you a 45-day license loss. So in other words, with this Cahill resolution, sometimes referred as a second chance first offender, you receive basically the same thing you got on your first OUI. You'll get usually a guilty 24D program and pay fines and fees and a 45-day license loss. On your first offense, you probably get a quaff. On the Cahill resolution, most judges will give you a guilty, but it's essentially the same punishment. You got to do the 24D over. What that does is it allows you to get back on the road, provided you get the interlock device. So you'll have the interlock device for, depending on whether you refused the breath test or took it and failed. If you took the breath test and failed, you're going to have the 30-day suspension for the breathalyzer being over 0.08. Then once if you resolve the case, or even if you're found guilty after trial, as long as you get the Cahill, in other words, the judge treats it as a first offender, you'll get a 45-day license loss. You'll be able to get back on the road right away, provided you get the interlock device. And you're going to have that device in your car for 2 years. But it'll be, your hardship will only be for the 45 days, and then after that period, you'll have your full license just with the interlock requirement. After 2 years, you'll be able to have the interlock removed. Now, if you refuse the breath test, you're going to have the interlock for a lot longer. So if you resolve the case and there's a refusal, you can get back on the road, but you'll have a hardship for 3 years, the refusal time. Then you'll have the interlock for essentially 5 years. So it'll be 3 for the refusal, then the 2 additional years will also be required on the interlock. So you'll have a hardship license for essentially 3 years and plus 45 days. Now that's vastly better than if the 2 OUIs are within 10 years. If they're within 10 years and you refuse the breathalyzer, you can't get a hardship at all for the 3 years. You can get back on the road, and I'm going to talk about that in a second, but there's no easy way to do it. So on a typical second offense, if the 2 offenses are within 10 years, it means they happened 10 years between each other when you consider the date of conviction from the first one and the date of the arrest. It's less than 10 years. Then you're looking at 3-year suspension for the refusal and a 2-year additional suspension if you're convicted or lose after trial on the OUI. Now, let's say you have a second offense within 10 years and there is a breath test. So you have a 30-day suspension for the breath test being over 08. If you resolve the case, then you'll have a 2-year suspension. You can get a hardship normally you have to wait a year to get a hardship, but we've been very successful getting people early hardships with the Board of Appeals. You'll probably have to wait at least 6 months before you can get that, but you're also going to have the interlock device. So there's a path to get back on the road if there's a breath test. Now, if you refused, here's why. You're going to have to win the case, basically. Otherwise, you're going to have the 3-year suspension. The Board of Appeals doesn't have any authority to give a hardship license on a refusal suspension. So you'll have to win the case or win the refusal appeal. The refusal appeals can be tough to win, but you either go to the registry, or if we're not doing, sometimes they'll let you do it by fax, depending on what's going on with society in the country and things like that. But normally you'd have to go there, but in some cases you might be able to do it by fax. So call me, I'll explain to you how to appeal the refusal. So when you appeal the refusal, you're saying that they can't prove the elements of a refusal. So typically you did straight out refuse. If that's the case, then I appeal it on some technical legal issues that the registry is not complying with the law in suspending your license. I've had some success with this. It's not a lot of success, but there are a few judges that will allow people their license back on this argument I've made. I haven't appealed it all the way to our highest court yet, but I think it's a good argument and it's worth making. Now, if you tried to take the breathalyzer, and some people try to take these and they can't get a accurate reading, then you can also appeal that, saying that you tried to take the test, you didn't refuse, but it was a medical issue. And that would be something the registry is almost certainly going to deny, but you can appeal that to the RMV, to the district court where your case is pending, to try to have that overturned. So the other way to get your license back, and the more common way I've gotten people their license back with a second offense of refusal, is we got to take the case to trial and win the trial. If you're found not guilty, we'd get an order from the judge reinstating your license for the refusal suspension. So what are the ways you can win an OUI case? Some of the things I look for is I look for video evidence that shows you don't look impaired. I look for good driving, and I break down anything you do right. We'll go to the scene, we'll look at it, we'll look at the turns, we'll look at how the road is structured, we'll try to break everything down to try to explain as much as we can that any driving was not attributed to alcohol. Field sobriety test, we kind of do the same thing. We want to show that these observations of the officer are not related to alcohol. Could be that you had a bad back, could be you worked that day. You're tired, we want to humanize you, we want to show that you're a good person. So we want to get all those details out. My father was a plumber, he's a hardworking guy. Like, if he ever was stopped for OUI, he breaks his back all day in basements. He's bending over, leaning down, and I used to work with him, and that's back-breaking work. And then if you go out socially after work, you're not going to be able to stand on one leg for as good as somebody who's sitting behind a desk, or who's younger, and so there's people that are disadvantaged of these tests. You're a nurse, you're on your feet all day. Even if you have a desk job, you might be sore from sitting. So there's a lot of ways where we can show that these tests aren't accurate. And it could be you don't do well on the test. You could be one of those people that are nervous when they're confronted by officers. But there's a lot of other things too they look for in the whole encounter, and we'll use that to show that you weren't under the influence of alcohol. For example, the way you provide your license and registration, they look at that and determine whether you bobbled it, fumbled it. We'll try to show that the way you provide the license was smooth, wasn't consistent with somebody under the influence of alcohol. The way you pull over, they look to see if you pull over safely and immediately. If you did that correctly, we'll say that that's another sign of somebody who's not under the influence of alcohol. And then how you behaved in booking, you cooperative, respectful, no issues with balance, you stood up for the fingerprints. We'll show all this stuff. And they got a heavy burden to prove a criminal charge. They prove it beyond a reasonable doubt, the highest degree of certainty. So that's why these cases are difficult to win. That's why I win these all the time. It's one, the passion to show the jury that I believe in the client, that I like the client, that I want to tell their story. They got a good person here. And when the jury sees that energy in me, it transfers over to how they view the case. If it's a tougher case where there's some things we need to explain, I'll have you testify. We'll get into all the details. We'll tell the jury that you have kids, children, a spouse, and what we'll try to do is we'll try to have them view you differently, that have you see the whole picture, that, hey, your day started early in the morning and this is what you were going through, for them to see that, this isn't somebody who was drinking excessively, but who's drinking socially and was a hardworking person, that they should want to help and be on your side. So if you have questions about any OUI case, or especially a case in Worcester or Westboro court, I handle cases out of these courts all the time, practice all over Massachusetts. The judges, they know me, I've been doing this, I write on OUI issues for Massachusetts Lawyers Weekly that all attorneys read. I've travel, speak on these issues. It's my passion. I'm happy to help you because OUIs are crimes that can happen to anybody. They're good people that are in difficult situations, and there's nothing more rewarding for me to help somebody who's stressed, who thinks this is going to end their life, and to help them move forward and get back to focusing on their goals, their career, and their family. So you can reach me anytime, myself, 781-686-5924.